how do I figure out if my idea is patentable? This is a great question. So patentability, I usually explain it in terms of two major hurdles to clear. The first one is eligibility. So do you have an invention that is even eligible, does even fit in the ballpark of the patent law? And so most things are, most creations, innovations are. Those that are excluded are those that are more natural phenomena, right? Things that are part of nature, DNA itself, right? Equations, right? Laws of physics, things like that will be, not eligible, even though you may have discovered a brand new principle, right? A new understanding of the world or of space, right? That discovery, while fascinating and amazing, is not something you can personally own. So that's what the patent law says. There's also another carve out for abstract ideas, where really there's no tangible way to say, yep, that's what it is, where you can actually point to it and explain where and how it exists, and to where, honestly, you'd be able to enforce it against an infringer. And so those are the areas to talk about with eligibility. So once you clear that hurdle, it's about patentability and whether you can get a patent on it. And there's three major criteria for functional utility, and that's you have to be novel, right? First of its kind ever. And that's not just what's been patented before, but what's been published forever and ever. And then the second big one is non-obvious. So even if it's brand new, first of its kind, no one's ever done it before, has there been any motivation or teaching or combination or suggestion that there's a way you could combine those, combine previous prior art, previous developments or technologies in the past to create this new invention you come up with. So if you clear those two hurdles and you can prove also that it has a benefit, a utility, you're patentable, and you should probably file immediately. So that's my quick, hopefully not too long explanation on patentability. David, would you offer anything else?
Only just that the non-obviousness of it is one of the trickier things, I feel, when you're trying to evaluate it. It's like, well, I think of a doorknob and they all tend to be shiny, brassy looking, whatever. And I come out of the rain and my hand slips on it. So putting like some texture on it, just a little bit of texture to give them just a little bit more grip. That might be non-obvious, yeah, or that might actually be a little obvious. It's one of these things where sometimes it depends on how you describe it, or when you're looking at something and you're going, that, oh, I see, I can see how that would be obvious. I can make it a little different. Right? You're the one that came up with it, so if you can go, oh, all right, okay, so we're not going to proceed with that patent. But I know how to change it just a little bit better, a little bit more, and then it is non-obvious, and you can proceed forward. So I'll just throw it out. Recognize that this obviousness concept, as difficult as it is for people who really know what it is to explain, don't just stop there, I guess is what I'm saying, because that's a tricky spot.
Yes, totally. Yeah, I would say work with someone who's got experience, and in those cases where it's close, where you're combining three or more, two or more pieces of prior art, it may very well be worth to just file. We'll work with the examiner, work on the claims, and get the claim scope.